Thank you very much. The next panel is titled Trademark Registration in the USPTO and the EUIPO, a comparative practical analysis. And we're going to be looking at exactly what it sounds like, with a bunch of awesome speakers. And I would like to introduce the moderator for this panel, Isa Junkar, who's a senior associate at the Alicante, Spain office of Hogan Lovells, a multinational firm. And Isa specializes in global portfolio management in trademarks and in also contentions and disputes, and has clients both in Europe and the United States and throughout the world. And we're very delighted that she's here to help us with this panel.
Thank you, David, for that introduction. And thank you, everybody, for being here today. As David mentioned, the task of our panel will be to discuss and compare the registration process at the USPTO and at the EUIPO, the European Union Registry. And to do that, we have an absolutely wonderful panel of speakers, which I have the pleasure to introduce to you. And I'll start right here with Meryl Hershkowitz, who is Deputy Commissioner for Trademark Operations at the USPTO. And she'll give us some insight into the USPTO registration practices. Then we have Barton, Beebe, and Jeanne who you already know, both professors of law here at NYU and our hosts. They'll provide us with some very interesting thoughts on trademark depletion and cluttering of the register. And then we have some EUIPO people here as well, sitting there at the end, actually. First is Gordon Humphreys, who's the chairperson of the Fifth Board of Appeal at the EUIPO. And sitting to his left is Joao Negrao, who's the Director of International Cooperation at and Legal Affairs Department at the EUIPO. So that's a mouthful, I think. And finally, we have Joao Ferretti over there, and he is the Vice President and Chief Counsel of Global Trademarks at PepsiCo. And Joe will have a wonderful task of drawing the whole panel together, I think, drawing on all his practical experience and bringing what we were talking about together. So I forgot to mention that I will be the first speaker, actually, so I don't have to compare myself to anybody. So I'm going to start off with EU trademarks. So I specialize in EU trademarks, and I am based in Alicante, where the EUIPO is also based, so that's the central registry for trademarks at the EU, and you can have a unitary right, as I think you know. So I named my presentation as getting the EU trademark that you want. That's because it's actually quite easy to get a trademark. You just file a form. But it might not be so easy to get the trademark that you want in terms of its scope of protection. So it's really important to understand the EU law and how the EU law works, as well as rules and practices of the EUIPO to ensure you get that right trademark. And I think that's quite important in this venue, where I think most of you are US-based lawyers, and those rules and practices will often be very different from what the USPTO does. So the point of my presentation really here is to try and pick out some of the more interesting rules and practices of the EUIPO. I think the watch this space kind of topics, which you should be aware of when you're trying to get a EU trademark. So to start off, it's very easy to get a trademark. You file a form, it's all online, you pay a fee. I'm not going to go into that because I'm not a representative of the EUIPO, but what then happens is the EUIPO takes a look at your trademarks, looks at the formalities of it, looks at the classification and specification, and then also looks at absolute grounds, in particular also whether your mark is distinctive, and this is, I think, the running topic of this panel, so I'm going to focus on that. There is, importantly, no relative grounds review ex officio by the EUIPO. Instead, the mark gets published for opposition purposes, and then third parties can file oppositions based on their prior rights. So that's that. So I'm going to start with, what can you register as an EU trademark? And in fact, I would rather start with what you cannot register as an EU trademark, because the first topic I wanted to discuss is descriptive, elusive words and slogans The EUIPO, I think it's fair to say, as a rule of thumb, applies a pretty strict approach to this kind of trademarks, and probably stricter than the USPTO, as Meryl will then correct me probably. Certainly it is more strict than most national registries that in EU, in my experience as a practicing lawyer. I have many clients who say, well, I have a national trademark, why can't I get a EU trademark? So that's the kind of the policy that the UI practice that the EUIPO has, I suppose, to avoid cluttering and so on. And one important issue is that even if you claim a figurative mark or lots of stylization, you're still probably not going to get your mark through. So I put on this slide a bunch of marks that have been recently refused. Gordon, I hope none from the boards that you have refused. Anyway, so these marks were all deemed not sufficiently distinctive. So there you go. Adding stylization is not going to get you there. So how about single letter signs? Single letter signs, you would think, since the EUIPO adopts such a strict approach, should also not be registrable. After all, there's a finite number of them, and they don't seem very distinctive, at least not to me. However, that is the wrong approach. Single letter signs are generally registrable. You can get a trademark for a single letter sign at the EUIPO, and that is partly caused by the wording of the legislation itself, which singles out single letter signs as signs capable of constituting a trademark. But also, we have a body, or at least two cases of the EU courts that are important, which actually state very clearly that a single letter sign has inherent distinctiveness, should be registrable, even if you do not add stylization to it. So on the left hand of this slide, I reproduced a couple of single letter signs that have been registered recently at the EUIPO. So as a rule of thumb, you're going to be able to get your single letter sign registered, even if you do not add a lot of stylization. However, as a rule of thumb, you will probably get about 10 or 15 oppositions, and then you can easily call me. I'll give you my card, and we can talk about that later. All right, so how about simple geometrical shapes? This is another interesting topic in the EU right now, because previously, about 6 years ago, 5-6 years ago, simple geometrical shapes were clearly registrable. You have lots of, especially fashion, footwear, and so on, sports footwear. Lots of these trademark owners have registered trademarks based on inherent distinctiveness, and that was the accepted practice. However, about 5 years ago, there was the courts, the EU courts, have started issuing a line of decisions which have made it now very clear that simple geometrical shapes simply are not registrable. And I reproduce a line of these decisions that are most important. So now we know that if you have that registration, you will be required at some point probably to show that it's acquired distinctiveness if it gets challenged, and if you want to apply for a trademark like this, you will have to show acquired distinctiveness. So that's kind of probably the right position, but as trademark practitioners, we're now in a very interesting space where single letter signs are clearly registrable, but simple geometrical shapes are clearly not registrable. The problem with that position, in my view anyway, is that there's sometimes very difficult to draw a clear line between the two, because a single letter is often just a simple geometrical shape or very similar to it, and I think this slide shows it quite well. So on the left-hand side, we've got a bunch of marks that were allowed, that were considered as registrable because they're single letter signs, whereas on the right-hand side of the slide, you see marks that were rejected because they're simple geometrical shapes. That's the way it is. We should probably watch this space area again. Now I wanted to quickly touch on also on the color in which you file your trademark, because it is, I would say from a practitioner's point of view anyway, and I might get corrected on that, there is a widespread practice of filing your mark in black and white when you do not wish to claim a color, because you might want to use it in different colors. And again, this is very common in the fashion industry, where you simply have to use your trademark in different colors, so that, you know, depending on the garment color, so that it's either for aesthetic purposes or visibility purposes. But in the fashion industry, it's just really difficult in practice to just choose a color. So we've been filing trademarks in black and white. There's thousands of these marks on the register, and there is good case law to support that you will have protection. Well, I would argue there's very good case law that you have protection in all colors. These are the cases that I've listed there. I'm not going to go into detail on them, but they're there. So what I wanted to show you here is this is what happens. You file a black and white mark, but in reality, you're going to use it here it's in inverted colors for a specific reason, but you can imagine having it in all sorts of other colors. So why am I talking about this? It's because the EUIPO actually currently does not adopt this approach, and it does consider black and white marks as limited to those two colors, so that when you are using it in a particular different color combination, it will be seen as a modification of your mark. So it doesn't necessarily mean that what you're using, your mark in color, that when you're using it, that will be deemed as genuine use. And the problem really arises when you have simple marks, such as the ones I showed you before, which might arguably change distinctive character once you alter their coloration. So it's again a watch this space area, because we're expecting a case, a judgment on this, hopefully from the EU courts. It's one case where I'm working on, so hopefully we get a decision there. It's an extended chamber, so I'm hoping they will address that point, but let's see. Now, I wanted to quickly touch as well on non-traditional trademarks, just to mention it, because I think it's an interesting topic. I don't know whether you know, but we in the EU consider ourselves as having a legislation that is extremely welcoming of non-traditional trademarks. The legislator from the inception of the EU trademark has actually said, I'm not going to limit signs to particular types. You can register anything under the sun, more or less, which can point to origin. So it has been considered a very good jurisdiction, even compared to other some national member states, a good jurisdiction for non-traditional trademarks. Also, we've had a reform of the trademark legislation recently, 2017. The EU trademark legislation was revised, and it was seen largely as, again, helping out non-traditional trademarks. One of the ways in which non-traditional markets were helped is by creating a list of trademark types, so that it is now much easier for you to say, oh, well, I want to have a position mark, I want to have a patron mark, I want to have a motion mark, I want to have a multimedia mark, or I want to have a hologram mark. So they've created this category, so it wasn't as ambiguous as it used to be in the past. So that all seems great, right? Actually, as practitioners in the EU, we do actually consider that non-traditional trademarks are going through a huge state of crisis. We have seen in the last 3 or 4 or 5 years a lot of famous trademarks being invalidated or denied protection, and some cases are still pending. So we do hope that there will be a swing in this pendulum. And I just wanted to highlight, as a watch this space area again, is this practice of mark types that you can select. In a way, it's great because it gives you certainty of what you're protecting. But on the other hand, it kind of takes away the previous practice, which was in place by the jurisprudence of the EU courts, which had a really common sense approach to looking at what you've sought to protect. So, for example, you would file a figurative trademark, and there is jurisprudence that said, well, what you really wanted is a shape mark, and because I'm looking at the goods and services that you're claiming, and I'm looking at the visual representation, and actually it's clear that you wanted a shape mark, or it's clear that you wanted a position mark, or it's clear that you wanted a patron mark in this particular line of examples. So I guess now with the new trademark types, that kind of common sense approach is no longer available. So you have to really be careful which trademark type you choose, because it's no longer just a ticking the box exercise. It will really define your scope of protection. And as probably as practitioners, what we're looking at is, what happens if our mark does not fall so neatly in any of these types that have been defined. You have the option to tick or to select other. But with so many types being listed now, I think the office will probably say, well, what is this other that you are claiming? So that's all about the types of signs, and I just wanted to very quickly touch on specifications, because this is again an area which is quite different from the US. In the EU, we use the NIS classification system, but there is no requirement to use or have any bona fide intention to use. You can basically file whatever you want. The only kind of limitation is that the goods and services must be specified with sufficient clarity and precision. And then certain parts of the NIS classification, the class headings have already been blacklisted as not being sufficiently clear and precise, such as, for example, machines or repair or treatment of materials. So some terms have been clearly thrown out, and we've been dealing with this a lot in the last few years. However, provided that you have been kind of avoided the blacklisted terms, you will usually be able to claim whatever you want. So I guess the sky is the limit at the EUIPO. I would certainly also, as a practitioner, never advise following the same specifications you filed at the USPTO, because they will be too narrow, and for enforcement purposes, you might end up having problems, especially where the scope of protection of your mark might be narrow. So that is, I just wanted to mention one thing, that there is a watch this space topic here as well, because there's been a recent reference by the UK court to the highest court in the EU, the Court of Justice, asking precisely this question: is the sky the limit? Whether a certain trademark can be invalidated because your goods and services have been too wide, or because these were too, so it's not sufficiently clear and precise, or because they're so wide that you clearly cannot be acting in all these areas, and so you've acted in bad faith. So that's a watch the space area, although I don't think that particular question is going to fly, and I think we will stay in the position in which we are at the moment. That's a bit of a, I think, a bit of a bet. So that's it. Thank you very much. I will now hand over to Meryl to tell you about the USPTO system.
Okay, where's the... Sorry. See if we can get... That's the wrong way. Okay. So, thanks to all of you for still being here. Good afternoon. My name, as we've said, is Meryl Hershkowitz, and I'm honored to be a member of this panel, who are very distinguished. And thanks to Russ and David for inviting the USPTO to participate. With the government shutdown, it was a little rock and roll coaster ride for me, but I'm glad to be here. And thanks to Isa for moderating. I'm going to jump around, obviously, in what I'm going to talk about. I'll try to cover everything Isa did, but if I didn't, please ask me in the question period. I'm going to talk a little bit about the practices in the United States and how they differ from other countries. And I'll briefly start by introducing you to the office and then concentrate on 4 practice areas. The role of the PTO is pretty clear. The primary role of the Trademark Organization is to examine trademark applications under the law and maintain the Federal Register. There's some side things we do with policy and international affairs and just educational things as well. The government requires us to be very consumer friendly, and we are constantly trying to improve our consumer experience. One way we do that is by being transparent, and we publish on our website. If you haven't explored the USPTO.gov website, I suggest you do so. It not only has an incredible amount of metrics and our goals and our strategic plan, it also has a lot of educational material, videos. We even have our basic facts book translated into Spanish and Chinese. So if you're interested in learning about trademarks, it's a great place to go. Also, you can see every trademark application 24 hours, 7 days a week, including every action issued, the prosecution history, and any decisions that are made. Okay, the Trademark Organization itself is a part of the U.S. Patent and Trademark Office. And the organization consists of 13,000 employees. The trademark part of it is only about 1,000. We do about the same amount of work. We had over 630,000 applications to handle in any given year, just like the number of patents, very, very close to 50-50 in our applications. But the way we examine is very different than what patent people do. For example, the Trademark Organization is mostly attorneys. We have about 750 attorneys who practice trademark law. About 600 of them at the moment are examining attorneys. And if you look at that chart, which you probably cannot see, it talks about the 27 law offices where we group people together. And we're just about to start our 28th. So we are a growing organization because for the last many years, the trademark applications have been growing. As Deputy Commissioner for Trademark Operations, I am responsible for all the employees in the law offices and the support staff that support them. The benefits of a trademark registration in the United States can't be understated. It's been recognized by the Supreme Court, and which can have positive and negative effects of that recognition. And we'll talk about that later when we talk about the recent Supreme Court cases on the First Amendment. But in any event, federal registration allows you national protection. You can go to the federal court and you get lots of presumptions. You can also register your mark with Customs and Border Protection, and the Customs and Border agents will seize counterfeit goods and infringing goods at the border so they don't come into the United States. We try as much as possible to register trademarks. We're not there to reject them. But the United States, as was referred to, is a little more difficult than a lot of countries. There's not an automatic registration. You have to get through all the hurdles that we give you. Because of that, I do believe we produce some of the most valuable trademarks in the world. As you know, if you go to Interbrand, Apple, Google, and Microsoft are now worth in the many billions of dollars. This is the registration process. What I do want to talk about that was just recently referred to is the requirement for use in commerce. So except for applications filed under the Madrid Protocol or the Paris Convention, every trademark applied for must have use in commerce. That use can be between the states or it can be between the US and a foreign nation. We do ask for a specimen, and those must be produced. Those specimens are actually how the mark is used in commerce, and that comes up as an important consideration for the examining attorney in several areas. The first one would be in likelihood of confusion. So this is a typical examination under the Seminole DuPont case, but mostly in examination, the examining attorneys are looking at just a few factors. Basically, how close are the marks in appearance, meaning, and connotation, and sound? Are the goods and services related? What are the channels of trade? What are the consumers? And finally, you must rely on the four corners of the application so that identifications of goods or recitation of services is extremely important and is one of the reasons why we require a lot of specificity. Specificity is super important for the United States. At one time, we did accept just computer software, believe it or not, back in the day. But as you know, that's saying that computer software for educational purposes versus computer software for running a factory are not really in the same channels of trade and probably would not cause confusion. So it is super important for us that the IDs be very specific. It cannot use common name. It must use common names, no class headings. It can't be indefinite, meaning we can't classify it. It can't be too broad, meaning it could fall in more than one class. It has to be specific, definite, clear, accurate, and concise, and tell the public exactly what the goods are. One positive area of harmonization, however, has taken place with the TM5. The TM5 is an organization that comprises the 5 largest trademark offices in the world: the United States, EUIPO, China, Japan, and South Korea. And we meet twice a year, and we have projects where we try to forward the idea of harmonization, or at least the idea of education between the offices. And one of the more successful projects is called the ID list. And right now we have 19,000 specifications where not only the TM5, but other countries that have joined us will accept those specifications in their application. We've also had a project called Common Status Descriptors, where we have icons on each application or registration that is very clear whether a mark is alive or dead, whether it's registered or in process. And you can know that simply by looking at these icons. You don't have to know Chinese or Japanese or Korean, and you will be able to understand the status of an application. Touching on non-traditional marks, the United States is wide open to anything that can function as a trademark. And that is the key, and we'll talk about that. But right now, you can see we have had smell marks in sewing thread that smelled like vanilla and plumeria blossoms. We've had touch marks, velvet on a bottle, and by the way, there's a 2 missing at the end of that registration number. That actually has just died. They didn't file their Section 8 affidavit. But there's another registration for the feel of leather on a wine bottle that is alive. Color marks like Tiffany blue, everybody knows that one, and the canary yellow for Post-it notes. We also know shape marks like the shape of the Pepperidge Farm cracker, the goldfish. The motion marks, again, Lamborghini claimed a motion mark and got it registered for the doors opening in the Lamborghini. And if this works, if I can do it, you can tell me some sound marks that, let's see if I can do this. Everyone probably knows. Let's see. Nope, that was not a good idea. Here we go. See if you recognize this mark. If we can hear it. No, it won't play. Sorry. Anyway, I'm sure you know it. It goes, and I can't sing, but it's three notes. Da da da. Right. Good. And how about the roar of the lion? Who owns that? Good. And that's just some. There's Intel's chimes. There's Tarzan. There's Bart Simpson's duh. And there's many other marks. Let's see, we have other kinds of marks that are, uh-oh. No, don't tell me I froze this. Yep, it's frozen. Anybody, any technical person out there who can help me? All right, while they're doing that, I will tell you, because we don't have a lot of time, I will tell you about other kinds of marks, which would be the design of the product itself or the packaging the product comes in. And I'm sure you know some of those famous marks, like Croc footwear, the Peep marshmallow candy, the Coca-Cola bottle, Mrs. Butterworth, the Crown Royal bottle. And the next thing I was going to show you was trade dress, which I also know you know, which is what, for example, the Apple Store looks like. That's also been registered. Now the point is, though, we don't just register these marks. Can you hear me, by the way? Yeah, good. We don't just register these marks and say they're inherently distinctive. The point is they have to serve as source indicators. And in the Walmart case, the Supreme Court said that a design of a product in and of itself can never be inherently distinctive. Other types of these non-traditional marks can also have been shown to never be inherently distinctive, like color, the single color mark. We talk about repeating patterns. We talk about other functional or non-functional things, like smell. So what we do in the office is we will register your mark if you can prove acquired distinctiveness. And the same thing is true for packaging materials. So packaging materials can be inherently distinctive, but most of the time they're not. And the 4 factors that we consider when we talk about inherent distinctiveness and product packaging is the proposed mark a common basic shape or design? Is it unique or unusual in the field in which it is used? Is it merely a refinement of a commonly adopted and well-known form of ornamentation for a particular class of goods? And is it capable of creating a commercial impression distinct from the accompanying words? So when we were talking about common shapes at the EUIPO, that wouldn't necessarily be a problem in the US if it acted as a source indicator and you had shown it acquired distinctiveness. So certainly the stripes on the Nike shoe have been registered. But a carrier for a mark, like a simple oval or a square, probably could never be registered. So it just depends on what you can prove. In the US, proving acquired distinctiveness can be done in several ways, depending on the strength of the mark. So do you own prior registrations? Have you had 5 years of substantially exclusive and continuous use? And what are your advertising dollars look like? I really did break it. Wow. Sorry about that. Okay, I've included, oh, good. Okay, thank you. Great. Okay, well, this is good because it just came in time for the case law. So I just included 2 recent cases, and my time is up, so I have to talk really fast. So you're going to have to read these yourself, but basically these were failed to function 3 colors on packaging. And this is a motion mark of a wrench where the wire crimpers turned, and that was found to be functional. I just wanted to give me a minute to talk about 2A issues because this is the latest and greatest at the Supreme Court. So in 2017, in the case called In Re Slants, in which a mark was examined for a band made up of Asian people, and the examiner said that the word slants was derogatory and disparaged them. And at that time, under Section 2A, we did not register disparaging marks. The Supreme Court in 2017 said that was that part of Section 2A of the Lanham Act was facially unconstitutional. So on the face of the statute, the Supreme Court said, no, that's unconstitutional under the First Amendment speech clause. Stay tuned for the latest and greatest Supreme Court case because we now have the immoral or scandalous provision of Section 2A under review. In Re Brunetti, the U.S. Court of Appeals for the Federal Circuit ruled that FUCT, and remember, there's no correct pronunciation of a trademark, but every single one counts in review. Everyone acknowledged it was vulgar, but the Federal Circuit said it was protected speech under the First Amendment. The Supreme Court has recently granted cert, and we expect oral argument in the spring. So stay tuned for that. I'll just throw out a question because I can't comment on the case because we're a litigant, obviously. I would just say, beware of slippery slopes. So if you have questions on trademark law, we have a lot of avenues for answering them, and I'll try to answer any questions we have now, right?
I think because we're running a little bit short, we'll save them for later. So let's continue on, and I think Barton and Jeanne are now going to...
Okay, thank you for your attention.
So thank you very much for being here today. So Barton and I are going to take turns discussing some work we recently completed, an empirical study of trademark applications and registrations, and then briefly talk about some ongoing and future work in this space. All of our work right now is focused on the US, but we will mention some work we're doing for other jurisdictions toward the end. And so some of you might have seen some of this data when it was a work in progress or in progress data, but now we've got some final results. And so we recently published the study of trademark depletion and congestion. Sometimes it gets called cluttering as well, or the related aspects. And what we found, just to summarize, is that the supply of competitively effective trademarks is not infinite, contrary to some premises of that sort in trademark law and doctrine. And we're reaching chronic levels of depletion and congestion. And we show this from a number of different ways that trademark applicants, for example, are changing the types of marks they seek to register. And at the same time, PTO's refusal rates on marks are continuing to rise, particularly on the grounds that marks are confusingly similar. And we think this is having quite an effect on the trademark system. So let me just start out with the conventional wisdom, and here are just, here's one version of this that you see in classic work on law and economics. You could find very similar quotes in, litany of court decisions over time. That the distinctive yet pronounceable combinations of letters to form words that will serve as a suitable trademark are, as a practical matter, infinite. Okay, so you could always find a new one. Something's been taken, there's always going to be a new one out there. And in a trivial sense, obviously that's true. You could always add letters to a word and just keep going ad infinitum. But we're going to try to test that claim and test that with regard to what we think are the competitively effective sets of trademarks. At the same time, you've seen something very different going on in media, and that is the suggestion that maybe a lot of trademarks are already taken, maybe all of them. So here's a New York Times story. Almost every naturally occurring word has been claimed, so people have to resort to other things like portmanteaus, combining words to form new words or respell words. Here's a nice quote from another article with a trademark expert. Every name we liked, either someone already had it or it wasn't trademarkable or it meant something pornographic in another language. Okay? So we decided, we're going to get to the bottom of this, study this, and we decided to look at 3 classes of words. We focused on word marks, and we decided to look at 3 classes of words that we thought were very much relied on as a source of marks. And in particular, common words in the English language, surnames, and new words, right? Sometimes people are coining marks as well, so we were looking at possible words one could construct in the American English language given the sounds of the language, and studying this over time and how, if at all, applicant behavior has changed to adjust for this. And so we put together a lot of data. Truly, it feels like big data. We used the trademark case files data set that the USPTO has provided, which has been a great resource. So thank you very, very much on that front. And so what it has in it are over 9 million observations of trademark registration applications filed from 1870 through 2017. And we focused on the more recent years. The data is more consistent. It also has all the live trademark registrations in there as well. We also put together our own data set of all USPTO trademark office actions. So we could look at, for example, the basis of a refusal. And that's available from 2003 going forward, so we have that collected through 2017. We also, to study the different sounds of the American English language, we have developed a data set that represents all trademarks. So there may not be a pronunciation, an official pronunciation of a trademark, but at the same time we use the pronunciation, the typical pronunciation of words as a way to phonetically transcribe all trademarks, so we could have a sound representation as well. And then we combine that with some other sources so we could look at these various categories that we thought were quite important in choosing marks. We use the Corpus of Contemporary American English, which is this huge source of lots of material, whether it's periodicals or books or news reports, showing how people use the American English language, which will give us a sense of which words are common and how frequently they're being used. the US Census, which gave us a lot of data on surnames in the United States, and also a data set of the .com domain names. So now I'm going to turn it over to Barton to discuss some of the data that we found.
Thanks, Jeanne. Good afternoon to all of you. I'm delighted to be here. It's really quite an honor to be at this event and on this panel, even more so. So, yeah, I'm here to give you some of the highlights of our findings. The full paper is quite long. It's like 90 or 100 pages or something. 100 pages. So in the next 4 or 5 minutes, I'm just going to sort of skip through a few teasers of what we find in the overall paper. And I want to second Jeanne's thanks to USPTO for providing these data. It's an extraordinary contribution to the academic community that PTO put together these data, and it's really like they are the best in the world in this. And I was thinking of this in the context of the recent unpleasantness in Washington, D.C. These civil servants really are leading the world in making their data available and making our careers possible. So it's just wonderful. To give a sense of context and scale to what I'm about to present, we thought it might be helpful first to talk about the overall number of applications that PTO has been receiving over the past few decades and the publication rate over those decades. So I realize after the first or second row, a lot of these numbers are going to be too small for you, but I'll just tell you in general, in 1985, PTO was receiving about 50,000 applications. By 2017, it was up nearly to 450,000 applications, a very significant run-up. All along, however, the publication rate has remained fairly steady, except for the events of the year 2000, the internet boom and bust, where we see a slight downturn. But otherwise, it's about 75 to 80% has been the publication rate. When we first came to this project, or at least I'll admit naively, when I first came to this project, I thought, let's just look at the publication rate and see if it's declining over time, because that would show that we're having more problems getting things registered. But of course, applicants are also looking at what's already registered and possibly changing their conduct in light of what they see on the registry already. And so we have to sort of take that into account as we look at some of the data going forward, including changes in applicant behavior, possibly in response to what they perceive to be conditions of depletion and congestion on the register. So I'll first talk about evidence of word mark depletion, which we try to define fairly specifically in a way that's maybe so technical it's hard to communicate orally or quickly. But we define trademark depletion as the process by which a decreasing number of potential marks remain available for registration in one or more classes of goods or services. And to study word mark depletion in particular, what we're really focusing on is the 2D situation. How often does someone walk into PTO seeking to register a mark and are told, no, that mark is already registered, or some similar mark is already registered, precluding you from getting registration for your mark? And to do so, we looked at various forms of identity and similarity. First, we looked at identical matches, and we mean identical. Apple would not match Apple Inc. if Apple Inc. is the registered mark. We also looked at within mark whole word matches. And finally, we used Jaro-Winkler edit distance to study fuzzy similarity. Apple versus Appful. Would they be confusingly similar? Now, in terms of regrettably giving you a sort of just a glimpse of some of our findings, we thought we would first focus on common word depletion, that is frequently used words in American English. And we've got this sort of little factoid, of the 1,000 most frequently used English words, 813 identically matched the registered single word trademark in 2016. And this table, which you can find in the larger paper, also gives you the same kinds of numbers for the 5,000 and 10,000 most frequently used words and up. Well, from a distance, then you could say, well, there's 187 words of the 1,000 most frequently used words that are still available, so no problems. And maybe if you project this out to the 10,000 or 50,000 most frequently used words, there's a lot left. But then if you start looking at the details of what is left, you realize that there's a problem. And this is what we found in a sort of qualitative manner every time we were going through the data. So of the 1,000 most frequently used words, here's a list. I realize it's impossibly small print for you in the back. Of the words that are still available, and let me give you some headlines of these words. We have words like dead, despite, died, difficult, disease, killed, lack, problem, problems, violence, perhaps is still unregistered, probably, trying, we're trying, brand, whatever, And my favorite was whatever, whatever brand, whatever, you know. Awesome, that mark is still available for you to get. Turns out whatever has since been registered. This then, the takeaway from this, if you'll permit just a quick summary, is that of this, about 75% of the time when Americans speak their English, they're using a word that identically matches a word already registered on the PTO trademark registry. And this line is attempting to give you a trend over time from 1985 through 2016. Trademark lawyers have every right to respond, hold on, if Apple registers in one particular class, that doesn't mean they own the word in all classes, though in the case of Apple, maybe they actually do. So in the paper, we also present data on particular classes, and because I'm already running out of time, I'll say that some of our favorite classes are class 25, apparel goods, where there's extreme evidence of depletion and congestion, class 9, high technology, class 41, involving services, entertainment services in particular. When we turn to Jaro-Winkler similarity, that is fuzzy similarity, we find some really extraordinary results even within particular classes. And here are some of the highlights. 97.1% of, in effect, the 100,000 most frequently used words in English are confusingly similar with an active trademark registration in 2016. This accounts for nearly 90% of our spoken English. All but 9 of the top 10,000 words are claimed. And what this graphic is trying to show you from a distance is that even in particular classes, the percentages are up to 70 or 80%. As for surnames, very quickly, because I think I'm out of time, as for surnames, our sort of quick little line is 55% of the US population has essentially been born too late to claim their surname as a unique mark on the trademark registry. We see similar sort of evidence of extreme depletion and congestion in particular classes. I will skip through to just a few details about responses to this by applicants and changes in applicant behavior, which we think are being caused by applicants' perception of depletion on the trademark registry. Applicants are shifting to neologisms. There's an increasing trend towards neologisms. And brand experts will tell you that neologisms are not preferred. Of course, we use them, but we prefer to use dictionary words, familiar words, which connote authenticity and familiarity. We also see a decline in registrations for surnames, perhaps in response to depletion. Word count is increasing, as is character count. Words are getting longer, as Jeanne suggested, where people are having to add things on to distinguish their marks from already registered marks. And I'll conclude just quickly with this. We are seeing increases in Section 2D refusal rates. This was hard-won data from scraping the PTO website, where in particular classes, specifically class 25, the dotted line, or classes 32 and 33 combined, the gray line, we're now seeing nearly 20% of applications are being met with a Section 2D refusal, which is an increase from previous years. And then finally, I'll honestly conclude with this result. Of those applications that are failing at PTO, an extraordinary percentage are now failing because of a 2D problem. So in a class like class 25 apparel goods, we have over 50% of those that are failing because of 2D. In classes 32 and 33 beverages, it's even higher, about 55% are failing because of Section 2D. So are we, both Jeanne and I are out of time completely, or?
Yeah.
Oh, okay. So I guess
Sorry.
I'll turn it over to the next speaker.
Yeah, thank you. Thanks so much. So we'll continue on with Gordon and Joao, who will give us a comparison of the EUIPO and WIPO systems. And I'm just gonna, it's gonna be a case study, so I have the task of telling you the background of the problem that we'll be facing. So Tonin is a small company it's a startup that was set up in Silicon Valley a few years ago and developed a great product, which is a voice recognition software for self-drive cars and semi-automated vehicles. The company has been very successful. It had very good conversations here in the States with Cadillac and Tesla and so forth. And their business really started growing. Tonin always knew that protecting intellectual property is important, so they filed for patent immediately, but as their business grew, they were advised that they also should get a trademark, so they filed for US trademark at the USPTO. However, a few months ago, they were advised that they should also expand their protection. They decided that they are not only interested in the US market, but they're also interested in the European market because of various reasons. There's an aging population, very popular to get self-drive cars, that they see it as a big market. They're also looking into getting trademarks in Mexico because they see it as a gateway to Latin America. And they're also very interested in getting protection in China because it's a big market, 1.4 billion people. So that's another area where they want to get trademark protection. In short, they want protection in Europe, China, Mexico. But the problem is they're a very small company. They do not want any particular or too much administration, and they need to keep everything as simple as possible. And so for that, and in order to shed some light on what are the options for tonin, we have here Joao and Gordon. So I think my first question goes to Joao. Can you tell us a little bit about what you guys do at the EUIPO and how this is relevant for tonin?
Sure, Isa. Thank you. And first of all, good afternoon, everyone. I think the first thing that there is to say is that the EUIPO, or the European Union Intellectual Property Office, it's an European Union agency based in Alicante, in Spain. The EUIPO is basically the European equivalent to the USPTO, except that we don't register patents, we just register trademarks and designs. Registration at the EUIPO offers protection in all, for the moment, 28 member states of the European Union, covering a population of just over 500 million citizens. You only need to make one filing and pay one fee. The basic fee for regular application is just under $1,000 and covers one class of goods and services. A second class adds nearly $60 to the bill. And the EU trademark is valid for 10 years and costs just under $1,000 to renew, provided you do it online. Unlike what happens, for instance, here in the US, you don't need to have used the trademark in Europe, or anyone else for that respect, before you apply for registration. In fact, because of the first to register system, you should apply for registration of your trademark before you enter into any deals with companies in the European Union. Once registered, you should make sure that within 5 years, you use your trademark for all goods and services that it covers. If you don't, then anyone can apply to the EUIPO to cancel the mark for non-use, for instance. That means that if Tonine hasn't yet actually started selling software in the European Union, they can still register the mark at the EUIPO, and they'll have 5 years to build up their European business. Importantly, as also mentioned before, the specification of goods and services doesn't need to be as targeted as in the US. For example, you can make a specification for voice recognition software without saying that it's for self-drive or semi-automated cars. That way, you're free to develop your business into new fields, like voice recognition software for cell phones, for military or aerospatial apparatus or appliances, without having to refile your mark. But EUIPO will require you to be clear and to be precise in the language you use, and it's a good idea for your specification to be identical or as close as possible to the US one, especially if you want to claim a priority from it. Applications at the EUIPO are examined on absolute grounds to make sure, for example, that they are not descriptive or generic in any of the 23 languages of the European Union. But applications are not checked ex officio on relative grounds. It's up to third parties to bring opposition proceedings within a set deadline. Nevertheless, it's still important to check before filing at the EUIPO that the trademark is available and unlikely to run into problems with opposition. Currently, some 20% of trademark applications end up being opposed by earlier EU trademarks or even national marks. At the outset, you should do clearance searches, for instance, in our database called TMView, probably the biggest trademark database in the world, containing trademark data from 62 jurisdictions in 35 languages and totally free of charge. This database was created in cooperation with the national offices of member states of the European Union and includes the trademark collections of all member states and beyond, such as the US, the Mexican, Brazilian, South Korean, Japan, and so on and so forth. We are currently working very hard alongside our TM5 partners, such as the USPTO, JPO, EUIPO, and CNIPA, to integrate the Chinese collection of more than 30 million trademarks into TMView this year, hopefully. Now, once a trademark has been registered, it can be cancelled on either absolute or relative grounds if proceedings are successfully brought against it by a third party. All decisions of the EUIPO can be appealed to the Boards of Appeal and then to the General Court of the European Union. On points of law, a further appeal lies to the Court of Justice of the European Union. Since Tonine has international aspirations, as you have mentioned, one of the questions that needs to be answered is how can rights granted by the EUIPO fit into the management of international trademarks portfolios?
Okay, so Joao, you've just explained how to file direct in Alicante for an EUTM, but there's another alternative, which is to apply for an international registration using the Madrid Protocol. And this is administered by the World Intellectual Property Organization based in Geneva in Switzerland. Now, since Tonin has a place of business in the US and has already applied for a US trademark, they can use that application as a so-called basic application to apply for an international trademark. Now, this can be done via the USPTO, provided it's for the same trademark, the same list of goods or services, or a narrower one as the US one. Well, the Madrid Protocol has over 100 signatories, and it includes China, Mexico, and the EU, which are all members. And you can designate any of those territories in your international application. Of course, be aware that when you make an international application, it doesn't guarantee that you'll actually get trademark protection in all those territories. You have to do clearance searches, as Joao just mentioned, in each of those territories that interest you to make sure that the trademark's available for protection. Then, of course, the trademark offices in those jurisdictions then examined whether they'll make an examination, but first of all, the USPTO, in the case that we've got here, will make sure that the information that's in the application actually is the same as for the US trademark application, and they charge a small fee for doing this. Next, the file will go to the WIPO, the WIPO, in Geneva, who'll make a brief formal check on the application before publishing it in the WIPO Gazette, and will issue you with an international registration certificate, and will notify the territories which you've designated as being of interest for extension of the protection. And there'll be a processing fee, obviously, for registering your international trademark, but it's less expensive than filing individual trademark applications in each of those territories. And then finally, the trademark authorities in each territory designated will have 18 months to examine the request for extension, and they'll apply their own trademark norms. And if no refusal to grant protection is made within that period of 18 months, then protection will be automatically granted. Now, once protection's granted, any subsequent transfers or licenses can be recorded centrally in Geneva, and renewal will be made on the same date for all the territories concerned. Now, that has obvious advantages for international trademark portfolio management.
Yeah, that sounds great, Gordon, but what should applicants be watching out for?
Well, in the first 5 years of existence of this international trademark, that trademark will depend on the validity of the basic registration or application. That means that if your US trademark never matures to registration in the example that we're given, or successfully attacked post-registration, your international trademark will perish to the same extent. And this process is known as central attack. In these circumstances, of course, you could transform your designations into individual national or regional applications. In the case of the EU, it would be a regional application. But that would be a lot more expensive. And also be aware that legal systems in many countries in the world don't contemplate acquisition of prior rights through use, but operate simply on a first-to-register basis. That's why clearance in searches, like using TM-View, are fundamental. It also means that there are some unscrupulous trademark squatters out there who register other people's signs and then try and sell them back. So don't be dilatory in applying for an international registration because it can have negative consequences. You'll also normally need local trademark attorneys if your request runs to extend protection runs into any difficulties in the territories concerned. Also, and this has been mentioned before, you need to check whether your trademark has a meaning in any of the languages of the territories that you're interested in. And remember, the EU has 23 official languages, and sometimes mistakes are innocently made. Another point to bear in mind is that a fee must be paid for each territory designated. And the cost of the international registration is the basic fee of around 645 US dollars, and a bit more for mark in color, plus additional costs depending on where you want to protect your mark and in how many classes you want to do it. But there are other ways of getting trademark protection in Europe, right, Joao?
Yeah, sure. Well, you could apply individually to the member states of the European Union. On the other hand, if you are sure that you will only be operating in a couple of EU markets, you could simply make an international registration with designations of those particular member states rather than the whole of the European Union. All EU member states are members of the Madrid Protocol in their own right, so you could extend to more territories as and when your business develops. Also, if you made all your applications within 6 months of the US one and use the same sign and list of goods and services, then you would get the US filing date as the date of priority for all of those member states. Each filing would be independent in this case, so if anything went wrong in one member state, it wouldn't affect the others. But overall, the choice about where and how to protect in Europe is clearly something that is directly connected with the company strategy. Gordon, do you have any final tips to share here?
Well, I'm really out of time, but just let me say that obviously search, investigate meanings, the international registration route is administratively convenient, but remember about central attack, and also consider about having to stick to the same or narrower list of goods and services. If you are registering in more than 3 EU member states, then as a rule of thumb, you might be just better off getting an EU registration direct with us. You have room to expand, and obviously there are the specification issues that we've mentioned before that can work to your favor. And you may also be able to get expedited proceedings, accelerated proceedings at the EU, but make sure whatever you do that you do your due diligence with language and earlier trademarks. Thank you.
Am I going the wrong way?
Yeah.
Am I going the wrong way here? This one? Should be forward, right? Okay, sorry about this. We'll try to get through to mine because I need to get to the graphics. Thank you very much for being here. I realize we're kind of running low on time. My name is Joe Ferretti. I'm a trademark lawyer at PepsiCo. Okay, there we go. I started off practice in Oklahoma, actually, as a litigator, and the first trial I ever had was a trial remember the TV show Matlock? The opposing counsel was basically Matlock, and he kind of stood up there, and he was well regarded, well respected, well known, and I was a young associate, and we actually weren't in the city, we were in a county courthouse where everyone knew him, and he stood up and he said, "Let me be brief." And 30 minutes into his opening statement, I'm thinking, when's this going to finish? And 45 minutes into it, the judge said, "Are we going to get to the end at this some point?" So I won't say it, but I will try to do it. So let me give you a little bit of background about where I come from, so the things that I look at to comment on just at least a couple of the things that were brought up before. So I'm at PepsiCo, and PepsiCo has a trademark portfolio globally of 55,000 trademarks. And we're in about 200 jurisdictions around the world. So the differences between the USPTO, EUIPO, WIPO, filing an IR are certainly very relevant to us. These are the types of products that we have. And here are some of the brands that we have that are our larger global brands, billion-dollar brands, and hopefully you will enjoy a number of these this weekend while you're watching the Super Bowl.
The big game.
So a couple things I want to comment on. I was asked to run through a couple scenarios, two to be exact, to talk about the registration process, how that works. Since this is a group of people that has very experienced practitioners and students, it's going to probably be less relevant on the specifics to the very experienced practitioners, a lot more relevant kind of as we go to students. So a couple comments that I want to make. Okay, so scenario number one. Before I get, we're going to talk about two situations. One situation where your client comes to you and says, "I have a new product, and what is it that we're to do?" The second scenario I want to cover is a situation in which you acquire a brand, you acquire a company, and the thought process that goes into that. Today as trademark attorneys, we recognize more and more, and it must be recognized, that we're brand attorneys. And you look at the direction that the International Trademark Association has gone, it's clearly embraced and put at the forefront that it's a branding organization. Same thing with Professor McCarthy and the McCarthy Institute, both acknowledging that it's not limited just to trademarks, but it's branding. Trademarks are certainly tools, but if we're to be effective, we need to understand the brand. And if you're in-house counsel, you're in a pretty unique situation to do that. I was outside counsel for 13 years, and I've been in-house for a little more than that. As outside counsel, you kind of know what your client tells you. As in-house counsel, you have the benefit to sit there with your clients and really understand the brand, understand the DNA. And to be effective in doing your job, I think it's really important to have discussions with the marketing folks to find out what it is they're doing, how they're doing it, what's important in this kind of brand ethos. And once you understand that and where they're going, then you can kind of more better analyze, okay, what are the aspects of this that I need to protect, and more importantly, how to protect it. So, this is a situation in which we created a new product in the U.S., and it was to be fruit chips or veggie chips. The branding was Flat Earth, okay, and Flat Earth with a tagline, "Impossibly good." The idea being, vegetable chips and fruit chips. At the time that we launched this, people could question, well, how good would those really be? So that's kind of the idea behind, and it turns out, they were awesome. But when you hear that, there's a little bit of a barrier. So I think it was incredibly creative branding, particularly to use when flying pig, because there's, when pigs fly, the identity I thought was incredibly unique. But for us, as the trademark lawyers, we had to understand that. And so what I usually do is I go to the marketing people and say, listen, give me more, I want you to understand not just the product, but I really need to understand the messaging. I need to understand where you're going, in 1 year, 3 years, 5 years. And so you try to get into and understand as much of the graphics, storyline, et cetera, and that helps you analyze a lot better as to what it is you need to file. Once we do that, then we analyze, I kind of ask 4 questions. What, how, where, and when. So what is the brand? And what is it that we need to file? There's logos, there's taglines. In this situation, there could be, package designs. If it's a beverage and there's a bottle, it's a unique bottle shape, could be a protection for the shape of a bottle. If there are unique food items in there, could be protection for the shape of the food items. That's kind of the what that we have to analyze and think about. The how is, what are we going to file? We're going to file a logo. We're going to file the word mark. We're going to file it stylized. We're going to file pack design. And then you kind of get into the copyrights. Maybe there's copyright protections available here. Let's make sure we look at domain names and social media handles. And then the where is always an important thing. If this launch is going to be in the US, let's say, well, where might it go? Where's the natural zone of expansion? Where might it go? Do we have any intent to take it further? And if that's the case, you really need to lock your marks up globally, or look globally to figure out where you might want to go. You might want to naturally go to Canada, Mexico, Europe, and you have to ask those questions. I've been in situations before where we have moved from one logo to another, and of course that's over time, and there's business reasons where it may happen at different times. We've done global filings on that, and there was a company in Central America that within a few months of a U.S. launch knocked us off in that country. But since we had done the filings, we were able to stop them pretty quickly. So it's important to be thinking about that right off the bat. And there are 2 times to think about it. One is the filing, and then in a lot of countries, of course, we have Paris Convention of 6 months. So you can take another swipe, or another bite at the apple within 6 months to then confirm if there's any other place to take it. And then when. Sometimes, it's rare, but sometimes there can be a when question. When do you file it? Sometimes there are launches that businesses, companies want to keep, not known very well. So you have to think about strategies on how important is that. You have to be protected, right? But the when sometimes comes into play. Sometimes I understand that there's some companies on a very kind of critical thing that they don't want it well known, will certainly use Paris Convention and file somewhere that is probably not watched as much, and get that going so their priority can start, at least for the Paris Convention countries, and then months later then make the broader filing a lot closer to the launch time. So, and this is, this kind of gets to what we were talking about, Isa was talking about with regard to, what type of marks to file. I mean, if there's a question, in Europe, I think the general understanding for companies has always been, you file in black and white, and that gives you the ability to move from into different colors. But as these issues arise, then you're kind of faced with the question of, I probably better file in both ways. I personally think it's a good idea to file both ways, but these are questions to ask. When you understand the brand and the DNA of the brand, hopefully you're not surprised when they go to the next round of product. And hopefully there's not many changes. But if you look up here, the logo is not being exactly used anymore. Certainly Impossibly Good is not front and center, and the flying pig has moved out little more outside the cloud. So then that begs the question on this kind of second launch, are there other things we need to protect, like the flying pig by itself? It also brings up an important question for practitioners to ask the client, which is, if we are taking this to other countries, do people get when pigs fly? Is that gonna make sense to people? Is it gonna make sense that there's a pig on the package, but you have fruit or vegetable chips? Is it going to, so instead of a pig flying, there are other things that in the local language, dialect, et cetera, could be similar. And then you also have to ask, whether or not it would be accepted culturally anyway. So those are a couple of that's it, kind of what we walk through with a new product launch. Here's a situation in which you bought a company, okay, and it comes with a trademark portfolio. And once the deal is closed, then it's up to you as the trademark practitioner to make sure that the portfolio is, kind of go back through your questions: what, how, when, where, and in asking yourself those questions, you already have familiarity with the portfolio because you did the due diligence, and so you have an understanding. When there's an acquisition, there's obviously some ideas about where you want to go, so you're put in a pretty good position, but it still requires you to kind of push the envelope by asking the questions. And a brand like Naked Juice, it's a very strong brand in the beverage field. But then you do have to ask the question, where else do we want to sell this? And could naked on a product be offensive in some countries? Would it not be offensive, but maybe would it not be desirable? You kind of have to walk through these questions, not just for a registrability standpoint, but then just from a commercial perspective. And if you take it out of smoothies, blend of fruits and vegetables, and you go into coconut water, and you take it kind of to the next step, does beg the question whether your specification is going to cover your goods. Probably should, right? But you still need to go back and look to ensure coverage. And then if you take the next step as you're growing your business, and it goes kind of in the food categories, again, same branding, same DNA. You may bump into a situation where, while you have an extremely strong brand in beverages, you may bump into dilution in foods. And in this situation, that's what we have. In fact, this is one of our products on the right-hand side. It's Stacy's Pita Chip, and then in the blue banner it says Simply Naked. So there are, I can cite to other examples too of the dilution that exists, in the food categories, even though you're very, very strong in beverages. That also brings up another question, you as a practitioner, which is to talk to your clients, because when you find yourself in a situation where you're using a similar mark for branding, you need to make sure that as the products evolve and graphics change, that you obviously don't bump into each other, because you do want to maintain the protectability that you have in even if it's narrower, because you do want to make sure that you do that. I am interested to, do want to comment on a couple things from the panel and from a couple perspectives that I have. I really do think that Barton and Jeanne's research is great. I think it's compelling and quite interesting. I will be interested to see if you guys, what your analysis is with regard to Europe. Because, I think based on the law, when I'm doing a search in the U.S., when searches come up, I already know, as Meryl said, that's being analyzed pretty carefully, right? And then whatever's registered has to be based on use, at least unless it's a 44D application, which is based on a foreign registration, in which case then you do find marks that are not required. They don't require use at that time. They will, and they can also be long specifications. And I see those from time to time, but not a ton. But I'll be interested to see what you all find, because when I'm doing search in the U.S. And I see, potential concerning marks, I kind of find that somewhat less frequently than I do in the EU. And it could just be a less scientific, I'm not doing a scientific approach. It could just be in, food and beverage. So I'll be interested to see, because in the EU, of course, as Joao was saying, there's no use required, and you kind of have a 5-year time frame to kind of more develop your business, and so your registrations can have broader goods and services. So I'll be interested on that. With regard to the IR, I think at least from an American company perspective, as Gordon was saying, if you base it on a U.S. registration or a U.S. application, there are certain things you need to keep in mind. On the one hand, it's great because it's incredibly efficient and incredibly cost-effective. On the other hand, if it's based on a U.S. application, your goods, of course, necessarily are going to be narrowed. And is that something that you want in, around the world? Or would you like to have the ability to file an EUTM, as Joao was saying, and give your business longer runway to develop those goods and services? So I think as practitioners, those are the types of questions that we need to ask ourselves. The benefit, though, in the EU is when I do a search and I'm looking, I do tend to find, I think, more hits that require analyzing. But on the flip side, the first thing that you look at as a practitioner is how old is it, right? Because if it's in Europe and it's 5 years old, then you can do a use investigation and see if it's still in use. In the U.S., the use is not as clear cut because it requires, first of all, on your application and at your Section 8 and 15, your renewal, it all requires use. So I think the U.S. system, as it's set up, gets rid of some of the dead marks, at least in my belief, probably more than because there's no mechanism in the EU for that. But since use requires an intent, if you want to cancel in the U.S., it's a little bit less clear because you have to determine if there's an intent not to resume use. So on the one hand, I think the U.S. I would suspect that there might be more cluttering in the EU on the one hand, but on the other hand, from a practical perspective, I think that it is easier to clear things, at least depending on how old the marks are. So, thank you very much.